Today's session is an overview of the discussion paper and the recommendations and the options we propose for forwarding that, the recommendations. Okay, the discussion paper is about improving the building rules assessment processes in South Australia. If these all of these recommendations are picked up, there will be a significant change for the way in which we do building rules assessments in South Australia. The committee made 20 recommendations. This discussion paper deals with essentially 9 of those, and if you like, they're probably the meatiest ones. There are another 5 which are being dealt with currently through auditing, the code of practice and the practice notes. So they're sort of wound up in that. There are 2 regulations which we believe adequately cover 2 of the recommendations. There's a proposed legislative amendment on one of the recommendations, and that's to do with the issue of consistency. If you've had a look through the discussion paper, you'll see that our proposal is that we actually remove the requirement for a certificate of consistency. There's only one that's not supported, and that was the recommendation for private certifiers having the ability to issue notices. There's been a further one which has been deferred for incorporation into a broader review of the planning system, and that's to do with stage consents. And finally, there is one further recommendation, and that has been referred to Crown Law because it's a legal matter. So that's a broad summary of where all of the recommendations sit, and we're basically looking at 9 in this particular presentation and in the discussion paper. So the key issues that came out of that are dealt with in this discussion paper are there. Primarily the registration of engineers, the issue of whether there should be certification of the calculations by engineers, the issue of assessing calculations, the registration of all building surveyors, whether there should be additional streams of private certification. We have only one in South Australia at the moment. Most jurisdictions have more than that. Whether there should be an independent authority established to deal with registration, and lastly, appeal rights. So they're the key issues that come out of the Select Committee recommendations. There are a number of other related issues, though, that we've tied in with this, because it's when we're talking about these issues, there are some related issues that come into play as well. Firstly, there's the naming of the accreditation levels. Now, I think most of you would be aware that the naming conventions that we have in Regulation 87 at the moment don't tie up with the naming that's used by the accreditation authority, which is ABES. So there's a need for some consistency there, and so there's proposals to move in that direction. There's an issue about the functions that are performed by level 3 building surveyors, and we'll have a closer look at that later on. And there's also an outstanding issue about what is the actual status of house energy rating assessors and how do they fit into this and their issuing of certificates. So we're, in the interest of having a consistent framework that deals with all of that, they've been brought into the mix as well. Okay, let's go through those key issues from the Select Committee one by one. The Select Committee made a number of recommendations that relate to the issue of registering engineers. It's quite clear that the Select Committee favoured the registration of structural engineers, and they also favoured a scheme that was proposed, it actually hasn't been implemented yet, in Western Australia. But it raises the issue, okay, if we're going to register engineers, what are the registration systems that are available? And what engineers actually fall within the scope of the building rules? In looking at the issue, and you can get all the arguments in the discussion paper itself, but in order to have a consistent framework and to implement the intent of those recommendations, we've come up with a preferred option that first of all would require any person who verifies compliance with a part of the building rules, they are to be registered. So essentially, if somebody is doing part of the assessment process and certifying compliance with the building rules, which is essentially what's happening, then they should be registered the same as a private certifier needs to be registered now. That's the first thing. Secondly, that all registered persons are subjected to the same degree of scrutiny and accountability as private certifiers. So we don't have different rules for some certifiers as distinct from other certifiers. So if you're a house energy rater or you're a structural engineer or a private certifier, essentially you are subject to the same degree of statutory scrutiny and accountability. That's important, accountability. And we believe the existing system for private certifiers works fairly well, and that basically we would build on the existing system rather than inventing something new. That system that we use at the moment is called a co-regulatory system. That's a system where the government, if you like, does all of the enforcement, compliance, if somebody needs to be smacked on the arm, then the government does that, and the industry looks after things like qualification, CBD, accreditation, those sorts of issues. It's a system that's used, as I said, certainly in South Australia, but it's also used, for instance, in Queensland for the registration of their engineers. They use the same system. And it is the system that was proposed for Western Australia. So it's using the co-regulatory system, and basically it means that, so as I said, people who are issuing certificates, first of all, are subject to registration, will be subject to auditing, will be subject to a complaint system, will be subject to a mandatory code of practice, and will have mandatory insurance requirements. So it's the same rules for everybody who issues a certificate. So that was the first issue. The second key issue that was raised by the Select Committee is to do with the certification by registered engineers. So we need to assume that the engineers are going to be registered. This raises a very interesting proposition because the fundamentals of the Development Act and the regulations, and indeed the whole reason for having building rules assessments, is that there be an independent check on the design, that nobody actually certifies their own work. So this recommendation would appear to be in conflict with that philosophy. The question, though, is if we are to act on this recommendation, then to what extent should an engineer be able to self-certify their own engineering design? It's a fundamental principle that's at stake, and it needs to be thought through. We're suggesting an option where the level of certification, the degree, the type of certification is commensurate with the level of risk associated with the building. So that for low risk construction, and we're asking for input on where the boundary lines is here, when we're asking for input on this, but for low risk construction, yeah, why not let an engineer self-certify their work? If the level of risk to life safety is very, very low, then why not let them do it? When you get to medium-rise buildings and buildings that, if you like, are built to, say, the deemed to satisfy requirements, where most of it's all laid out in the codes and standards, then yes, okay, there needs to be a check of the design engineer's work, but that could be done in-house. Provided the engineer's a registered engineer, why not let that be done in-house? A lot of engineering firms have their own quality assurance programs, and they do have independent checks within the engineering firm. And then, of course, you get to the really complex buildings, the ones where you're using innovative design, you might be departing from the codes and standards to some extent, and they're public buildings. There's a risk, there's a general risk and a general community expectation that those sorts of buildings would be checked by somebody completely independent of the design. So we're suggesting that there be a three-tier level of certification, dependent on the level of risk. And importantly, we think that the decision about when a particular project should go from one to the other should be left to the discretion of the building surveyor. The building surveyor is taking prime responsibility, if you like, for the overall consent process, and the building surveyor should be the one who decides whether on a particular project, no, it shouldn't be self-certified, it should actually be certified by another engineer, but it can be done in-house. Or this is really complicated, you know, you're really way out there here, I want it independently checked. So we're proposing that that would be the building surveyor that actually makes that call. The third area that the Select Committee recommendations dealt with is the assessment of calculations. And there's a number of ways that the Select Committee tried to deal with this issue. Fundamentally, what's at stake here is what is the relationship between the certification by engineers with the building rules assessment? And if we're going to go to all of this trouble of making sure that engineers are registered, there is a seat in the middle. If we're going to go to all of this trouble, what's the trade-off? There's got to be a benefit. In improvement in processes and administration, it can't be done just for the sake of it. So we're proposing that if we have registration by certifying engineers, that in fact the need for a building surveyor to have responsibility for making sure there is an independent check is largely removed. So we would propose removing the reference to calculations in Regulation 87. Any assistance to help in the when you ask for certification and levels of certification can be in practice notes and in the Code of Practice. So that there won't be a need for people to make sure that there is this separate independent check. It means that calculations, for instance, footing designs, which, you know, just about everybody gets on a standard house. It may be the only engineering thing that you actually see on a standard house will be the footing design. But if the engineer that's done that footing design is a registered engineer, why not just accept self-certification by the engineer? Why do you need a separate check? This opens up the possibility of building surveyors not having to make sure of engineer. They can ask for a certificate on any calculations that they get. If there are non-certified calculations, they can either A, ask for them. They can, if they're engineers themselves, check them themselves. And they're really the two options, one or the other. And if you were wanting to have calculations that you can rely on, then you ask for certification. And the more often building surveyors ask for certification, the more engineers will actually get registered. So then we come to the issue of registering all building surveyors, and the Select Committee did make recommendations along these lines. And the question is, well, do we really want to register all building surveyors? Is it all building surveyors that we're trying to capture here? What are we really trying to do? And essentially it's about equity, being equitable with what the private certifiers are responsible for. So essentially what we're talking about are people that have a decision-making authority, that have the ability to make a decision on whether to grant a building rules consent or not. So it needn't capture the ones who are just providing advice, and there are plenty of building surveyors who just provide advice, both to private certifiers and to councils. We're not really interested in registering those as such. They need to be accredited, but they don't need to be registered. So we're really looking at people who have some form of delegated authority in councils to be able to issue a building rules consent. So that's our preferred option, is to have that requirement that they be registered in some form, and that in being registered they then become subject to all the other scrutiny and accountability of private certifiers. They take on that responsibility. And as such would be subject to all of the issues about complaints, auditing, registration, codes of practice, and would be linked in that way to satisfy those recommendations. The next issue to deal with that the Select Committee dealt with was the issue of introducing additional streams of private certification. There's good reason for that, both in terms of national consistency and the issue of mutual recognition. We can have somebody apply from interstate to be registered in South Australia. They may be level 2 building surveyors, but if they register to practice in South Australia as a private certifier, we cannot refuse them. So we already have an issue of South Australia not being nationally consistent, and yet mutual recognition will mean that we have to allow them to practice. So we're proposing, and the issue has been around for a number of years. The only reason it hasn't been introduced in South Australia is because we didn't have an auditing system in place. That is in place now, and operating quite well so far from what we've been learning from it, and it's been a steep learning curve. So there's the opportunity to introduce level 2 private certifiers. and to open it up to another level. As part of that though, we do have another issue that crops up time and time again, and that's the issue of the number of years of experience. South Australia actually requires 8 years of experience for a building surveyor from accreditation, not from the date of qualification, but from the date of accreditation, 8 years experience before they can be registered. Whereas in other jurisdictions it's 3 years from the date of qualification. So there are important differences there, and we propose addressing those so that we are, again, nationally consistent. Next is the issue of an independent authority. This was first raised by the Planning Review. They suggested an independent board be established. The Select Committee, they didn't say specifically an independent board, but they did refer to the need to establish a need for an independent body. And the question then is, well, what should be the nature of that independent body? There are a number of different models. So you can have a board, and the jurisdictions where there is a board tend to have the highest fees. In fact, they're extremely high fees. Whereas those that contain it within the public service as an independent position within the public service, they tend to have lower fees. And it's much easier to maintain. Because we are talking about relatively small numbers, even if we register engineers, we estimate that we're still only looking at about 500 people all up. It's not a big number. We're not talking the thousands that they have in New South Wales or Victoria. In order to have a cost-effective system, we're proposing that the independent authority be an independent position within the public sector. We've said a registrar, but it can be any name we want to call it. But it would have an independence similar to that of the technical regulator. It's built into legislation. It is established in legislation as being an independent position. And that makes the administration a lot easier. That independent position, though, won't be able to do everything themselves, and particularly when you're dealing with things like registration, you're trying to determine whether a person's qualifications are adequate or not. Do they have the skills and competencies? There's probably a need for that independent person to have the advice of an advisory committee, people who would be able to advise on things like competencies and qualifications. If you get qualifications that you're not familiar with, how do we actually go through a process? Who can we turn to get advice on whether those qualifications are reasonable and what we expect from a person acting in a statutory role in South Australia? So having established an independent authority, we then have the issue of appeal rights. The Select Committee was very clear that there should be appeal rights. Certainly don't disagree with that. The question, though, is who should the appeal be to? Is it to a person, a panel, a tribunal, or the court? There are a lot of different models for dealing with appeals. In South Australia, we don't have a single administrative area that deals with appeals. In some jurisdictions they do. So firstly it's about where should the appeal be to, and then what types of decisions. Essentially, I think the types of decisions are about whether a person agrees with the registration decision or not. Secondly, whether there's a decision in relation to a complaint that they disagree with and want to appeal against. And lastly, if there's any disciplinary action that's proposed that again they might have an issue with. It would need to apply to everybody that's registered under the Act, so whoever's registered, all those registered certifiers would need to be brought into this. We're proposing that it be a panel, but we're really interested in people's thoughts on this, and it might be that there need to be a couple of appeal mechanisms. For instance, if it's an appeal to do with skills and competencies, that is registration, that might be to an expert panel. But if you're doing an appeal on the basis that the recommendation is that you be deregistered, you probably want that to go to the courts. If you put appeals to the courts, that's going to bring in, of course, lawyers. So there's an issue about the extent to which the appeal, where does that appeal need to go to? At the moment we're suggesting it goes to a panel, and that there need to be a public officer who actually takes it through the process. But we're really interested in people's thoughts on that, because it's a fairly important issue, is where should the appeal actually go to? That essentially deals with the key issues that came out of the Select Committee. So moving on, the naming of the accreditation levels, we need to change Regulation 87. What we're proposing is to pick up the terminology that's used in the National Accreditation Framework. That's the general model that's used nationally. So we're proposing to pick up their terminology. That is, it would be Building Surveyor Level 1, 2 and 3. And if you're a private certifier, you'd be Private Certifier Level 1 and 2. We're not proposing to extend that to Level 3, certainly not at this stage. Generally in other states they only have 2 levels, although Queensland is thinking about a 3rd at the moment. Next, we have a discontinuity with the Level 3 building surveyors at the moment. In South Australia, our Level 3, well, that is the building surveying technician level, is able to do work on some 2s and 9 buildings, where they're not just limited to housing. But the qualifications, if you do the qualifications at the moment to get accredited at that level, that training only takes you to the extent that you can assess housing. It actually doesn't take you into those other classifications. So there's an issue there that we need to align what we are prescribing that these people are allowed to do with their level of training that they actually get. So we need to make a change there. Now that raises, of course, a very important issue of, well, what about those people who are already doing that work now? And there will need to be transitional arrangements. So there's no reason why people who are doing that work now should not continue to do it. But we will need to have some transitional arrangements for those. But any new people coming through with the training that's in place right now, then they would be limited. This is just an overview, if you like, of how we see this fitting together in some sort of framework. So basically you've got varying degrees of building work. You've got housing, which is fairly low risk. You've got your medium type development, the sorts of development that you get with shopping centres. And then you get your complex and innovative buildings, like the medical centre across the road. Highly innovative. So we already know and we are familiar with the building assessment part of it, the level of assessment the qualifications for people doing that work being roughly relates to the level of risk of those buildings. What we're then suggesting is that in terms of a decision-making power, anybody that issues a certificate, again, the degree to which you're able to certify, self-certify, is again related to the level of risk in the building. And that is also commensurate with the issuing of the consent, where your level 1 building certifier is basically able to deal with all buildings, and your level 2 building surveyor, level 2 building certifier has some restrictions placed on them. So we believe that provides a more coherent framework than what we have now, and basically makes it fairly clear where people's responsibilities and accountabilities lie. We can apply that to the house energy raters, as I said. Basically they get captured by all of this, subject to the same requirements for registration, auditing, complaints, codes of practice and insurance requirements. Much more stringent than what we have at the moment, and it means that we would actually need to provide legislatively a role for house energy raters, which doesn't exist at the moment. It is purely a voluntary system. So that's all I've got in terms of the discussion paper, the issues in the discussion paper. Hopefully you've got some of your questions answered and you have a better understanding of what's being proposed. So thank you once again.